Well, thank you, everybody. Well, if you could just take your seats and make sure your cell phones are off, and we'll get started with our concurrent breakout session for this afternoon. The topic is the Affordable Care Act and the politics of reproductive health care, and presenting to us is Jessie Hill, who is a professor and associate dean for faculty development and research at Case Western Reserve University School of Law. Ms. Hill's teaching focuses on constitutional law, civil rights, reproductive rights, and law and religion. She is a graduate of Brown University and Harvard Law School. Her scholarship has been published in the Michigan Law Review, Duke Law Journal, Columbia Journal of Gender and Law, and the Texas Law Review, among others. Prior to teaching, Professor Hill worked at the Reproductive Freedom Project at the National ACLU office in New York, litigating challenges to state law restrictions on reproductive rights, and then practiced First Amendment and civil rights law with a small law firm in Cleveland. She is a member of the Academic Advisory Board of Law Students for Reproductive Justice and is a frequent lecturer and consultant on reproductive rights issues. So please join me in welcoming Jessie Hall. Thank you.
Thank you. So I'm really pleased to be here talking about this subject, which, as you can tell, is really near and dear to my heart. I don't know if you can tell, but I'm wearing my royal blue today for the Royals. I guess you're allowed to, even if you were a Cardinals fan, I guess you're allowed to cheer for them now. So, my husband has been a long-suffering Royals fan. So what I want to talk about is as sort of indicated by the learning objectives, actually, I want to talk about both the effect of the ACA on reproductive health care and the politics surrounding it, but also to talk about the ways in which the politics that surround reproductive health care and the political debate is really part of the broader political dimension that has always been there with respect to health care. That the ACA and the reproductive health controversy that it's bringing out is sort of the most salient example of the way in which politics are implicated in health care, but that this is only one of many ways in which politics are entwined in health care, and always have been. I'm going to talk about mostly sort of my focus is on the national level. I'm coming to you from Ohio. I don't have a Missouri or Kansas focus to my talk today, but I am going to want to leave maybe a little bit of time for question and answer, so that if you want to talk more about some of the specifics of what's going on here or in other states, we can do that during the Q&A. Okay. So I want to spend a little bit of time talking about what the Affordable Care Act has had to say about reproductive health care and the impact that it has on access to reproductive health care. You might recall that the big controversy over the Stupak amendment to the Affordable Care Act, which ultimately did not pass and then was replaced with the Nelson Amendment, which was all wrapped up in this debate around whether we would have taxpayer-funded abortion under Obamacare. And basically the compromise that was reached is a state of affairs where there is no federal funds that directly go to pay for abortions, or what are called elective abortions, but that and also that any insurance companies providing insurance on the exchanges have to segregate any funds that are used to pay for abortions. So they have to segregate a certain premium amount of premiums that are paid, and they have to keep a separate account that's used to pay for any abortions if they provide abortion insurance. So the idea is that people are buying health care on the exchanges with federal subsidies, and the federal subsidies, they have to keep the funds separate so that those federal subsidies are not going to pay directly for abortions. Also under the ACA and this political compromise that was reached with respect to abortion, states have a lot of discretion with respect to their own exchanges and can decline to allow coverage for abortion on their healthcare exchanges. So, and a number of states have taken advantage of that. Actually, Missouri and Kansas have both pretty much banned coverage, insurance coverage for so-called elective abortion, which means anything, in these states means anything but life-saving abortion procedures. So they've banned it completely in both the private market and all of the healthcare insurance exchanges. You can, as part of a comprehensive plan, you can, at least theoretically, buy a separate abortion rider policy. Not clear whether that actually exists or not, or is going to exist, but in theory, at least, you could buy supplemental riders. In addition, again, as part of this grand compromise, at least one multi-state plan has to offer a plan. So at least one multi-state plan that's offered in each state has to exclude coverage for abortion. So there has to be, if there is a multi-state plan, which is a great idea under the ACA, that's supposed to increase competition and lower costs for insurance in general, health insurance in general. If there are multi-state plans, each state has to have at least one multi-state plan that does not cover abortion. It seems that has ended up meaning that actually none of them do. Because really, why would you bother if you're putting together a multi-state plan? It just adds a level of complication to add a benefit that you then have to exclude in certain places. So basically, it seems that at this point in time, as best we can tell, no multi-state plans provide coverage for abortion. So where does this leave us? And then, of course, also the ACA says that abortion cannot be designated as an essential health benefit that's required to be covered. I think when I step close to those, I'm getting feedback. Okay, sorry. So where does this leave us? Well, there's an article by a couple of law professors, Karen Rothenberg and Rachel Rebouchet, who argue that Obamacare has essentially these mixed messages about abortion, and then comparing that to its message on prenatal genetic testing and diagnosis. So, for example, on the one hand, the Obamacare, the Affordable Care Act, stigmatizes and isolates abortion within reproductive health care. At the same time, it does seem that it seems to have a relatively favorable attitude toward prenatal testing and genetic testing and prenatal testing in general. Although it's not explicitly required to be covered, it kind of depends on the state. It's arguably could be included under the requirement to cover prenatal care. Some states already require coverage of prenatal genetic testing. And it's been recommended by the Institute of Medicine as a preventive service that should be covered as a routine part of prenatal care. So on the one hand, the Affordable Care Act encourages, at least to some extent, prenatal testing and diagnosis for fetal anomalies, and on the other hand, again, isolates and stigmatizes abortion care. Another significant impact, potentially, that the Affordable Care Act may have on reproductive health care is through the Medicaid expansion. To the extent that states choose to expand Medicaid, Medicaid already covers contraception, testing, prenatal care. That could be one of the most significant impacts, positive impacts that the ACA has on reproductive health care. And then, of course, the big one that's been in the news lately and that everyone is paying attention to, contraceptives coverage. And this has been a long, ongoing controversy over the decision to designate contraceptives as essential health care, as part of the essential health benefits that are covered under the rubric of preventive services. And along with that, the Affordable Care Act has maintained existing conscience protections that were already in the law And then, as we'll talk about with the Hobby Lobby case, recently the Supreme Court has gone further than that. So, I think I want to take a few minutes to talk about Hobby Lobby, although, you probably have heard enough about it or a lot about it already. But I want to raise, I want to suggest that, again, that Hobby Lobby is in some ways just the tip of the iceberg. That the Affordable Care Act has exposed and will continue to expose and to aggravate divisions over what is the meaning of health and what is the meaning of health care, and that these disputes have kind of always been there, these deep political disagreements, and that they are just, they've remained kind of submerged or relatively submerged, except in certain contexts until now. I mean, after all, the term Obamacare itself, right, kind of suggests this alliance between politics and health, right? Like the name of a political figure being incorporated into the name of a healthcare program. He's not a doctor, but it's sort of Obamacare suggests it's his care plan. Okay. So a couple of points that I want to make about this. I mean, the big one is the one that I think is represented by Hobby Lobby, about the way in which we have long disputed the meaning of health and health care, and that it has been a highly politicized question all along. Of course, Hobby Lobby represents the big question about whether contraception is health care, right? It actually, the Hobby Lobby case emerges from a long political struggle over defining contraception as a part of essential health care for women. It grows out of a movement for contraceptive equity that actually the culmination was the coverage of contraception in Obamacare as an essential health benefit. But the movement for so-called contraceptive equity, for coverage of contraceptives on the same terms as other preventive health care, goes back to at least the 1990s. And on the other hand, so on the one hand, there is this struggle by feminist groups and women's health advocates to frame contraception as an aspect of women's health as essential to gender equity. And on the other hand, an attempt by groups opposing that movement to frame it as a political and moral choice, and as, of course, an infringement of religious liberty if they have to assist in providing it. We actually, another example of the way in which these disputes really indicate deeper disagreements about what is healthcare and what does healthcare mean. In Ohio, actually, again, where I'm coming from, after the Affordable Care Act was adopted, we had a state constitutional amendment on our ballot, which I still actually cannot believe it was that it passed. So it was adopted by an overwhelming majority of Ohio voters, and it's called the Ohio Healthcare Freedom Amendment. And it's one of these, I mean, a number of states have these sort of anti-Obamacare amendments that pretended to say, our state doesn't have to follow Obamacare, which is just silly because states can't decide to opt out of federal law. So on the one hand, it seems like a sort of silly law, but the one that Ohio adopted is really, really sweeping, and it actually says, no one shall be compelled to or prohibited from or penalized for buying or refusing to buy health care or health insurance. I mean, think about that. That is almost like a complete deregulation of the healthcare industry. And it purports to, it only applies to laws passed after a certain date, basically the date Obamacare went into effect. But it's uniquely kind of sweeping. And so this was sponsored by, again, sort of anti-Obamacare groups who were largely sort of libertarian organizations. And then immediately after it passed, someone said, well, what about all those abortion restrictions that you just passed in the state as well in the same legislative session? And I don't know if it had never occurred to anyone who was backing this amendment to ask themselves this question, but the sort of lead proponent of the law said, well, abortion isn't health care. So it doesn't apply to abortion because abortion isn't health care. I mean, makes you wonder what it is and why the Department of Health regulates it and why it has to be done by doctors if it's not health care, right? But we can kind of see this like complete disjunction kind of in our understandings of where reproductive health care fits within health care more broadly. Okay, so what about Hobby Lobby? There are a lot of interesting things about Hobby Lobby. Since I'm my areas of teaching and scholarship are both law and religion and reproductive rights, this is sort of right in my wheelhouse, and I can't help taking a few minutes to talk about the Hobby Lobby decision itself. So what was Hobby Lobby about? I'm sure you all know Hobby Lobby, a large corporation but closely held, right, owned by a family, essentially, has about 13,000 employees, but the owners are Christians who interpret their religious principles such that they are morally opposed to abortion. And they claimed that the requirement they had to cover 4 types of contraception violated their religious beliefs because they believed that these types of contraception were abortifacients. And they were basically emergency contraception and IUDs. And the reason they thought that they were abortifacients is they said that these contraceptives had a post-fertilization effect, and or could have a post-fertilization effect. And according to their religious beliefs, life begins at conception, i.e. fertilization, and any birth control method that could act to stop a fertilized egg from implanting was an abortifacient. And so the Supreme Court had to answer several questions when they claimed that this requirement violated their religious liberty. And actually, this is maybe kind of a geeky lawyer point, but I have to make it. It's actually not a constitutional case. It was brought under a federal statute called RFRA, the Religious Freedom Restoration Act, which actually provides religious protections that go beyond the First Amendment. It's more protective than the First Amendment would have been, actually. So under RFRA, first we had to decide, is Hobby Lobby a person who's exercising religious freedom? Famously, the court said yes, at least as a matter of interpreting RFRA, interpreting this law. Second, were their religious beliefs substantially burdened? The court said they think that they're being complicit in abortion. If they don't provide this health insurance, they're subject to massive fines, millions of dollars a year. Yes, clearly they're being substantially burdened. And then, if that's the case, under RFRA, then you then have to say, well, does the government have a compelling interest in what it's doing, in imposing this requirement on Hobby Lobby anyway? And is it doing that in the least restrictive way, in the way that's the least burdensome to Hobby Lobby? And that's where the court said, well, the contraceptives coverage requirement, I don't know, the government says it serves interests like gender equality and public health, and let's just assume those are compelling interests. Okay, so we're not even gonna say they're compelling interests, we're just gonna yeah, whatever. Okay, it doesn't matter because, so the court was not even willing, couldn't even get a majority to say these were compelling interests. And then said, okay, assuming that, then the problem is still that this is not the least restrictive way the government could have done this, the least burdensome way. Really what the government has to do is just pay for it itself, or give Hobby Lobby the same deal it gives to religious nonprofits. And if you work for a religious nonprofit that objects to providing you contraceptive coverage, basically there's a deal under which you can still get coverage directly from the insurance company or the third-party administrator if it's a self-insured employer. and you pay nothing, the employer pays nothing, and the insurer bears the cost. Okay, there are a lot of things to take issue with here. One is that I think the real problem is the substantial burden. One of the real problems is the substantial burden notion. First of all, the court completely ignored, and probably completely ignored because the government completely ignored, that this is most likely a severe factual misunderstanding of what actually happens with these forms of contraception. At least with respect to Plan B, there is virtually no evidence that it has it almost certainly does not have a post-fertilization effect ever. There was some argument to the effect that the other emergency contraceptive, Ella, might, although there's really, again, not good evidence that it does have a post-fertilization effect. Same thing is true with IUDs. We simply don't know. We are almost certain, either almost certain that they don't, or at most just don't know. And it's bizarre to me, although it's not that bizarre because the government also didn't really make much of this, but it's bizarre to me that that flew completely under the radar. And I think that this, again, has something to do with, well, this was really just seen as a religious liberty case, and we were happy to rush over the actual biology of women's reproduction and get straight to the question of whether religious freedom was being burdened here. I think it's really troubling, for reasons I'll come back to later, that the court was unwilling to say that gender equality or public health is a compelling governmental interest. And I also think it's really troubling that we now have, whenever there's an option for the government to pay for something instead of having it provided by a private employer, that then there's basically no reason a private employer ever has to provide it. The government could always just take on the cost. So, and the dissent made a big point of this, saying, where's the limiting principle? What about vaccines? What about other forms of healthcare that employers might object to? What about just all contraceptives? Does the government have to pay for all of that just because they can? Okay, so I'll move on to this next slide. So that's Hobby Lobby. So, but again, I think that what Hobby Lobby gets at is a broader disagreement, a deeper disagreement about what is health. What are concepts like, what do concepts like medical necessity and essential health benefits mean? And have we ever had any real consensus around that? Like I said, Hobby Lobby actually grows out of this movement for contraceptive equity that women's health advocates were bringing lawsuits back in the late 90s and early 2000s to get employers. This was not in the case of religious employers or employers who had religious objections. They were bringing lawsuits saying not covering contraception in your employer-provided health care plan on the same terms that you cover other preventive health care and prescription drugs is a violation of Title VII. It's gender discrimination. It's sex discrimination. You're covering everything except the one drug that is used only by women and that, by the way, accounts for a huge portion of out-of-pocket health care costs for women and means that they pay about 68% more out-of-pocket than men do for health care. And courts were actually starting to grapple with this issue. And there were a couple of cases finding that it did violate Title VII for employers, that it was gender discrimination for employers not to provide this coverage in an otherwise comprehensive plan. And there was an interesting sort of exchange in one of the cases where one employer who was resisting providing contraceptives coverage, and again, not for religious reasons, and they didn't claim they had religious objections. I'm actually not sure why they objected because it's actually cost effective. But they said, well, pregnancy is not a disease. It's a natural state. So that's why, contraception is not health care. And, the court said, look, unintended pregnancy obviously has negative health effects, but it also has negative social effects, right? And I think that this is where that question comes in. To what extent is healthcare health, sort of, to what extent do we take into account social determinants, social needs? To what extent is there a social dimension to what healthcare is? Of course, we've long realized that allocation of healthcare is inherently a political and moral decision. We have limited resources. We have to decide who gets them, how we divide our limited resources. But also distinguishing what is therapeutic from non-therapeutic is inherently political and moral. So, I sort of object to the entire category of elective abortion, although it constantly gets used in these political debates, right? To call abortion elective is already to say, well, it's not, right? It's not a medical need. It's kind of a luxury. All right, but we could think of other types of, I'm trying to sort of hurry through my remaining slides here, but we could think of other sorts of healthcare that maybe, if we came up with a definition of medical necessity, we might come up with one or of what is therapeutic. For example, if you look at the Institute of Medicine report that was prepared in helping the government come up with, to help HHS come up with the definition of essential health benefits. The Institute of Medicine said, well, when we're talking about medical interventions, medically necessary interventions, we're talking about interventions that are clinically appropriate, evidence-based, and have a health benefit that justifies the cost in comparison to other alternatives. Yeah, well, I think that's a sensible definition, but where do things like reproductive health care fit into that, right? I think it depends on how you define what costs are and how you define what a health benefit is to the person. We might think of other things too in that area, circumcision, breast reconstruction after a mastectomy. Things like this that are not, strictly speaking, functional interventions, but that are do have some benefit, at least part of which is sort of socially derived, rather than strictly related to physical health. And so I think that this is something that has long been the case with reproductive health care, but again is somewhat present in all forms of healthcare discussions. I know this is like an anti-Obamacare poster, and I'm not anti-Obamacare. I just think it's a really funny picture. So, so what's going on here? Well, I think we have all of these players who are involved in regulating healthcare and thus in defining healthcare, and they're all doing it independently on different levels and in different ways. But with Obamacare, we are moving from a very decentralized healthcare decision-making system to an increasingly centralized one, from decisions being made very much at the private level of the individual physician and patient or individual payer, insurer, to probably more standardization on that front. And I think that is part of what is going to has made and is going to continue to make debates over the meaning of health and healthcare increasingly salient in our politics. And also, I think that, as I'll talk about on the next slide as well, there's been something of a shift from an understanding of equality, or a rhetoric of equality around healthcare and reproductive healthcare, to this overwhelming rhetoric around liberty. I should have the religious liberty not to provide contraceptives coverage. I should have liberty not to be subject to the individual mandate, right? To have to buy health insurance. So just a few thoughts about how we got here, and then what's still to come. I think. And this is again, why are we in this place where healthcare is so very politicized, especially reproductive healthcare, and these debates are particularly salient right now, part of the issue, I think, has been the isolation of reproductive health care from healthcare generally. And in my view, to some extent, that is the product both of legal doctrine and of pro-choice activism. It's been a little bit of an unintended consequence of pro-choice activism, which intentionally moved to take abortion and reproductive health out of the hands of doctors, to say, it's not up to you. We're not putting it in hospitals anymore. We're putting it in these separate buildings, right? And now it's in a separate building, so protesters can come protest, right? And everybody knows where it's happening, and we can say those are not real doctors or act like they're not real doctors. They're in some special class that gets regulated separately. The initial move was just simply to give authority and autonomy to women, but I think it's had this unintended effect of isolating reproductive health care, so that somebody can say, abortion's not health care. And also, again, that there is just we're in this libertarian moment politically, I think. That this idea that we're all about individual responsibility and we just cannot see ourselves as connected to everyone else. I mean, I think that the Supreme Court's decision in the Sebelius case, saying that the Commerce Clause didn't justify the individual mandate, but upholding the mandate, obviously. But its view that that this is just not part of interstate commerce, and that the whole rhetoric around the individual mandate was one of seeing individuals as individually at one moment making a decision to buy or not buy health insurance, instead of viewing the health care as part of the interconnected whole of a larger economy, of a larger political body, of a larger set of decisions over a lifetime. And I think the same thing happens with abortion regulation. There's a similar dynamic where states restricting abortion really tend to sort of focus on that moment of decision. You have to look at an ultrasound. You have to hear a heartbeat. You have to have, a 72-hour waiting period now in Missouri, right, to really think about your decision, as if this was the product of as if abortion is something that happens the minute a woman walks into a clinic, and that's the first time she's thought about it. That's the first moment that's led to this happening. It's very bizarre, treating it as this isolated moment, this isolated decision in time, as opposed to part of a continuum of choice, coercion, whatever else might be going on in the woman's life, social forces, family forces, and a whole network of forces that are influencing her decision. So I think that that's part of this just broader libertarian kind of rhetoric that we're surrounded by right now. Okay. So I'm not going to spend too much time on this. Maybe we can talk more if people have questions. But I can't help touching on, are there going to be other cases that are going to come up with employers who are going to want to refuse health care on religious and moral grounds? I think Hobby Lobby absolutely opens the door for that. I don't see any limiting principle in Hobby Lobby, and the court did a very unconvincing job of saying that there was a limiting principle there. And, even left open the door for large corporations to do this. I mean, I'm not convinced that it stops there. I will bet you, though, and you can take this to the bank, I will bet you that every case we see from here on out is about contraception, emergency contraception, IUDs. I bet we don't see a single transfusion, vaccination, or anything like that case. You know why? They don't care if you're vaccinating your kid. Even if they don't believe in vaccines or they don't believe in blood transfusions, they do not, trust me, they do not care if you are vaccinating your kid or giving your kid a blood transfusion with their money, right? They just don't want, Hobby Lobby just doesn't want women taking what they think are abortifacients, right? And this is about obstructing that part of the program, obstructing access. It is not, I will bet you anything, it is not about complicity in sin, right? About complicity in healthcare that they object to. So I will bet we don't see any vaccination cases. I bet we don't see any transfusion cases. We'll see. Time will tell. Okay, I'm going to stop there. I think there may be other sort of constitutional fights to come over Obamacare coverage and so on, but I think I want to stop and leave time for Q&A unless you want me to just keep talking, but I'll stop there. Yeah.
So I agree with you. I think that the vaccination question and the blood transfusion question will not be relevant because I mean, there's not a complicity there, and I don't see a direct link. However, I think in end-of-life care there is a direct link. And when we start talking about removing feeding tubes or withdrawing patients from life-supporting technologies, or even perhaps transitioning to palliative care where choices for life-sustaining treatment, such as in ongoing cancer treatment, are made. And there are very conservative views about choosing death, choosing dignified death versus choosing life at all costs. I think that question may come up.
Well, that's interesting.
Maybe,
although it's hard to, I guess the issue with that is it's hard to see what role the employer-provided health insurance would have, right? Because I guess they can require coverage.
It would be carving out coverage for end-of-life care.
It would be
carving out certain forms of coverage, such as hospice care.
That they would not want to cover hospice care, for example.
Certain components of critical care, if the choice is made to allow the patient to die in a critical care environment where they're no longer going to provide life-sustaining treatment.
I see. That seems plausible. I mean, certainly we all remember the Terry Schiavo case that was not that long ago. So that is another kind of rallying point as opposed to transfusions and vaccines. And God forbid it's a pregnant woman, then we have it even 100-fold, right? Doubly troubling. But yeah, that's possible. That is possible. Yeah, in the back.
Can you please clarify at the very beginning of your presentation, you said something about to the effect that federal abortion dollars are being set aside through the federal exchanges. Is that?
I'm sorry. Yeah, I might have brushed over that quickly. So no. So what happens is, if an insurance company is on an exchange, whether it's a federally sponsored exchange or a state-sponsored exchange, if one of those insurance companies offering policies on the exchange wants to offer abortion coverage, because people who are buying insurance on the exchange many of them are getting federal subsidies to do that. The idea is that to avoid that money that's coming from the federal government to the taxpayer and then to the insurer, we don't want any of that to pay for abortions. So is the idea. So the insurance companies have to create a separate account that pays for abortions, and they have to take a certain percentage of premiums and put it into that account. So there's a kind of fiction that they are creating a separate abortion fund if they're going to provide abortion coverage that keeps the federal dollars kind of clean. That doesn't is the idea. They're segregating the funds that are used to pay for and then reimburse for abortions. And then in some states, you're not allowed to even do that. You have to offer a whole separate rider policy, which again, it's unclear to me that anyone is actually doing either or going to do it for very long because it's such a pain. Why would they bother? Yeah. I think some still are offering coverage, but I don't know how much longer. Yeah.
Do you see a legal strategy that would introduce the science back into the issue?
Yeah, it's an interesting question. I mean, it's really disappointing that that the court never paid attention to this question, and courts have been doing this quite a bit with abortion restrictions and kind of, I don't know how much you've been following informed consent requirements where women have to be told, they have a risk of breast cancer, increased risk of breast cancer, suicide, mental health risks, things like that, things that are not true, basically. And courts have been extremely lenient to say, well, if there's any way to read it, or if there's any any version in which that could be true, sort of any sense in which that could be true, or if there's any evidence to support it at all, we just defer to the legislature. I really think that courts have not been helping us on this. Yeah, no. I don't know. I don't have a lot of hope for a legal strategy. Yeah.
I've often wondered about the purchasing power of and the impact of employers making these decisions. You know, you see the protesters on the sidewalk, but, you know, that's one day. I wonder if what the impact of the market is going to have on those decisions.
On what decisions?
On, like, Hobby Lobby's decision.
Yeah,
You know,
yeah.
are they going to see an impact on their business?
Right, right. And I don't know, you know, I mean, and maybe to some extent they see the opposite impact if they're in places where people support that decision. So I think that, you know, people will go out of their way to shop at Hobby Lobby too if they agree. So we can't generalize about women. Another thing I gather is that Hobby Lobby actually used to have an insurance plan that covered these methods of contraception before Obamacare. And so, which again just makes you wonder, I really think this is sort of a, you know, this was a publicity stunt, like kind of through and through in a way, to kind of say, you know, this is our stance. And I actually think it was maybe a stance against Obamacare as much as anything else. Not completely. I mean, I do think it was also against abortion, but so yeah. So, and I guess, and that plays well too. That sort of taking a stance against Obamacare. So, I always feel like I leave here with such a depressing tenor, but leave these talks like everybody's depressed when they leave it.
Well, this will be a bit more uplifting. They don't have Hobby Lobby where I'm from.
Oh, good.
But it did make the news. We get international news, so that was a bit of a dig, sorry. I'm just wondering if you know, what about access to, like, provided by Hobby Lobby's insurance plan? Is there available for women who are seeking or wish to seek reproductive technologies such as IVF?
She asked whether Hobby Lobby's insurance would cover access to IVF or similar reproductive technologies. I don't think that they object to that, so I don't, although often insurance doesn't just because of costs and it's not required, so I don't know offhand. I don't know. Yeah, that's a good question.
Just curious.
Yeah, yes.
Sort of two questions. One is sort of the scope of the implications of Hobby Lobby. Does that mean any company out there, somebody who's the CEO can say, you know, I object to this, so I want to follow the same thing? And do they just get that, or does it have to go through the legal system again? And the other one is there, what does it take to bring this, since there were some real errors in this, what does it take to bring it up, to revisit it? Does it take, like, some company saying, you know, I don't believe in surgery or transfusion, so I'm not going to, I'm sorry, we're not covering that here, and that might surface up and cause us to be revisited.
Yeah. Okay, so let me take the first question about now, what does this mean? Yeah, and I'm glad you asked that, because so post Hobby Lobby, what's going on now is, of course, the government says, you know, you can pay. Well, the government can't just start paying for something, right? I mean, you have to have a program. There was no program that was in place to pay. Good luck getting Congress to pass something, right? So what the Obama administration said they were going to do is they are going to try to create a rule to give companies like Hobby Lobby the benefit of the exemption that religious nonprofits get, whereby, you know, the insurer pays, but the nonprofit doesn't have any premium associated with paying for contraception. And so they've announced that they are in the process of making a rule, which is the process by which that happens. That takes like forever. So, I mean, it takes at least 60 days, but usually much, much longer. And we don't know what that rule looks like yet. They've just given what's known as a notice of proposed rulemaking. So the rule is being worked on, so we don't actually know how it's going to work. In the meantime, of course, Hobby Lobby's employees are not at all covered. And yeah, presumably anyone can now object. And I think that that's one of the really disturbing things about this is now the employer is empowered to say, I don't want to cover it. Employees, you know, if you want to fight me, you can try to take me to court. But now, you know, I have all this room in the world to just say no. It sort of shifted the momentum to the employer. And also, somebody had asked me once, like, what if a woman needs contraception for health reasons, like she has a medical condition, you know, uterine cysts or something. And My guess, again, I don't know if this has ever actually played out, but my guess is, before, insurance companies would just cover that under some, medical necessity coding. Now, I suspect if the company has objected officially to covering contraception, that the woman is now going to have to she's not going to be able to submit a claim. She's going to probably have to go to her employer and tell him or her, Mr. Green, father, whatever, I need contraception, and now the onus is probably going to be on her to get that. So again, we don't know exactly how this works out. The second question was, is there a way to get it back before the court?
Bring this up to be revisited.
Yeah, I do think that it's definitely coming back, because already now not Hobby Lobby, but a religious nonprofit has objected to even having to opt out. We don't even want to fill out the form that says we have religious objections, because that's making us complicit in contraception. Again, if that doesn't tip you off that this is about getting rid of access to contraception, not about religious objections, I think nothing will. So I think, something like that. I mean, eventually, I think that that might be that might be what breaks the camel's back. I think the court might finally say, "You got to be kidding us." So, but we'll see. It'll be another claim like that gets more unreasonable. Yeah. Sorry.
So,
Yeah.
I've been embroiled in many of these discussions since the Hobby Lobby cases.
Uh-huh.
And my understanding is, in individuals who have responded to some of the comments that I've made, is that that contraception itself, that actually prevents conception, is not covered in the narrow decision that was made.
Right.
So that hormonal treatment for individuals with endometriosis or with other conditions that do require the medical intervention, that is not covered, and that's still required.
Right.
It's only those interventions, it's only the hormonal treatment or the interventions that actually disrupt the continuation of pregnancy after conception.
Right. So because those are the only forms that Hobby Lobby objected to. So it's only the post-fertilization or purported post-fertilization contraception. But but the reason I kind of made that leap is because there is nothing, as far as I can see, in Hobby Lobby that prevents the next employer who objects to all contraception. I mean, there's just you can't find anything in there. Yeah, I mean, there is, I should dial back. There is a little bit of hedging. I mean, there is language that says, well, these, it's only 4 forms, and, 2 of them are emergency, and, but on the other hand, 2 of them are the most expensive, right, and most effective forms, so the IUDs. So,
Mirena is the gold standard for some female medical issues. So Mirena placement is now medical as well.
Right.
I mean, and that's one of their 4.
Right, exactly. And the court's logic that, their religion is substantially burdened because they're having to do something that violates their beliefs on penalty of, millions of dollars, and that maybe it's a compelling interest, but who cares because the government can always pay. I mean, that clearly would apply to other forms of contraception, and there are plenty of employers out there. That was more my point. You're right that Hobby Lobby is just those 4. And I actually don't know. I mean, this is all developing very quickly, and most of the companies that object are, I think, a lot of them are already tied up in litigation over this. So, but I assume the ones who object to all forms of contraception are simply not providing it now. I don't know.
Are there other rulings that identify corporation as a person, as this has done? Because that's what this does.
For purposes of RFRA, which is the federal statute. So no, there haven't been, this is the first one. That was the first decision to do that. I can see why that's troubling, and I do think, with a big company like Hobby Lobby or a company like, what if you get to a publicly traded company, that it's troubling. But I actually think that's in some ways the least troubling aspect of the opinion because, there are religiously oriented companies. I mean, Hobby Lobby does also own this Christian bookstores, Mardell, and what about the company that, I don't know, makes only kosher foods or something, right? I mean, you can see that there are some companies that are organized only around religious ends, and I don't know that you can necessarily exclude them from this law just because they're companies, they're corporations, because they use the corporate form. But yeah, like I said, I mean, I can see why it's troubling when you get to a certain size, but I think Hobby Lobby is, or I think that's one of the least troubling parts of Hobby Lobby. I also think, I mean, there's some, eventually the Supreme Court is going to have to decide whether gender equality is really a compelling interest or not. I mean, I think, what about the next case that's not about health care at all, that's about a desire, not to pay women the same as men, or, to say, well, we don't think women who are pregnant or mothers should be in the workplace, right? Again, eventually the court is going to have to say whether that's, whether there's really a compelling enough interest in keeping women in the workplace to override employers' beliefs, because that fits within the same statute. RFRA isn't just about health care. Was there a hand? I thought that, no.
So a claim of discrimination would be the natural challenge, I think, that would come, that would take this back.
Yeah. Yeah.
I mean, to me, this is employers, regardless of your religious belief, employers have special obligations to their employees.
Mm-hmm.
Because the employees are in a more vulnerable position. And as such, you have a special obligation not to impose your belief system on them, mm-hmm. and not to impose certain requirements on them that are onerous, mm-hmm. and indeed dangerous, mm-hmm. which in this case it would be. Mm-hmm. And I think that there's a very compelling ethical argument as to why Hobby Lobby should be held to task.
Yeah. 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 Sorry. I'll take a question. Well, I was just going to give a little context around RFRA too, but maybe I'll take a question.
Well,
yeah.
And this may feel like you get some context around RFRA too. What about recent news? What about employers who may have an objection to providing coverage to same-sex spouses,
right.
and how can Hobby Lobby fit into those?
Right. Right, so that's interesting, and that was one of the examples I was thinking of throwing out there, because right now, so that's a matter of state law, and because the federal government doesn't have any requirements protecting, doesn't have any anti-discrimination protections for same-sex couples. I mean, other than that the federal government has to recognize their marriages. But at this point, there's no federal law requiring that sort of thing, but state laws do and might increasingly. But something about RFRA is that law only applies to the federal government. It doesn't restrict what state governments can do. So it was the fact that it was a federal health care program that particularly gave Hobby Lobby this really strong argument, because like I said, that statute is actually more protective than the First Amendment. If you are trying to fight a state law because it violates your religious beliefs, you only have the First Amendment as your tool, and that's actually much weaker, and they almost certainly lose under the First Amendment. But that issue, but I think the day is going to come when that issue represents itself, and when the federal government does require coverage of same-sex couples' health benefits, and then it's going to be the same thing all over again. And I was just, and that actually does kind of lead into a little context around RFRA. So RFRA is this law that was adopted in 1993, and what had happened is, in 1990, the Supreme Court had a decision in a case called Employment Division v. Smith. It was a case involving a Native American who was fired for smoking peyote in a religious ceremony. And the Supreme Court basically upheld the law that he could be fired, and said, when you have a neutral law, like a drug law, that applies to everyone, no one gets a religious exemption. Only if the law, unless there's a really, again, compelling reason and so on. But no one gets an exemption. The only case in which in which there is a problem under the First Amendment is if the law specifically targets religion. But if it's a general law that doesn't target religion, it's fine. And Congress didn't like this at all, and there was a huge outcry afterwards. A lot of it was interesting because it was a coalition of religious conservatives or religious individuals and civil libertarians who said this violates religious freedoms. This is horrible. And Congress got together in 1993 and passed the Religious Freedom Restoration Act. In 1997, the Supreme Court struck down that law, the Religious Freedom Restoration Act, as applied to the states, but not the federal government. And the reason is kind of complicated and technical, but basically it's not super relevant, but left the state of affairs where RFRA applied to the federal government but not to the states. So Congress got back together and said, okay, we got to find another way to pass a new law that will protect the states. And they tried, and they had gotten together this law that they thought would pass constitutional muster, and called all the civil liberties groups back on board and all the pro-religious rights groups back on board. And in between, what started to happen was these lawsuits where religious individuals, it was particularly, there was a series of landlord cases where they didn't want to rent to either same-sex couples or unmarried couples, and all of a sudden groups like the ACLU went, oh my God, this means, these religious protections mean that they are being given a right to discriminate. And they all peeled off. And so there is a replacement law that came after RFRA, but it's a really weak law and it only applies in certain narrow contexts. It was all they could get passed, basically something that applies to prisoners and land use decisions. So, not relevant here. So this is kind of all. This is this interesting remnant from this battle. It's sort of like RFRA could have only happened in this era before we started realizing that these fights were coming over same-sex couples and same-sex marriage and homosexuality, but after all the fights over race were done, because no one was trying to make a claim anymore that they got to discriminate on the basis of race under religion, right? That was the 60s, that was the 70s. Nobody had made a claim like that in years. We weren't even worried about it yet, and we also weren't yet worried about equal rights for homosexuals. So it was this moment that RFRA grew out of, and I don't think it would happen again. Yeah. Right. No. Right. Exactly. No. That. Yeah. Probably didn't make it onto the radar screen. Yeah. So. Well, I think we are at 4:15. I know it's been a long afternoon, so. I guess I should probably wrap up. I'll stick around a little bit if anybody wants to chat some more, but thank you very much.